Good evening. This is Laws 11057 Introduction to Law. It's term 3 of 2014 and tonight is week number 2. We're going to be covering chapter 3 of the new lawyer, which deals with a history of Australian law. Before I do that, can I make some comments in relation to the way in which students are embracing the subject so far? I'm really happy with the feedback that I'm seeing. I do see a lot of enthusiasm. I see a lot of interaction, and I'm very pleased to see people are sharing material. They're adding commentaries, they're providing links to useful information, and all of that is both noted and highly encouraged. So please continue in that practice. I really appreciate it. By now you should have been through the Moodle site, got a feel for how that looks. You should be using UCrew, and many people are. I trust that you've at least flicked through the new lawyer, had a look at each one of the chapters, and indeed had a look at a practical guide to legal research as well. So I want you to be diligent and enthusiastic enough to ensure that you read in advance of the week's tutorial each week. So you can ask questions. Please ask questions through UCrew and Moodle as well. By now, I hope that you've looked at the assessment pieces and that you've worked out how to upload the assessment. And Erin has already uploaded her assessment. I'm not sure if anyone else has, but you should at least have that assignment and you should be well into it by now. For those of you who have registered tonight, you've obviously found your way through to Zoom, so thank you. If you haven't found your way through to Zoom, you should register so that you're able to join live if you wish. Hopefully you've started to form some study groups, and Sharon and Peter, I guess have their own study group automatically. But try and get some study groups. Map out your study plan. I would be disappointed if you're not spending more time on this subject than any other subject if you're doing more than one subject. So I really do, and I said this last week, I want to work your heart because you'll get much more out of it if you do throw yourself into it. Now, next week I'll talk about it in more detail, but please do look at my sample document if you haven't already. You'll find it at the bottom page of Moodle. I think there's a link to it in UCrew as well. It's not just a document that you look at in terms of the form, but there is also substance in that document, so I'd like you to read it carefully. So your written work needs to be of a certain standard. We want to ensure that it is of very good quality in terms of its presentation and professionalism. I'm very keen to ensure that students who are studying law at Central Queensland University are very highly regarded, and we are aiming high. I also want to ensure that as you progress through to other subjects, either in the law faculty or elsewhere, that people will recognise that you've been through Introduction to Law and you've reached a certain standard. All right. So are there any questions in relation to any of those things that I've mentioned so far? No questions? All right, and don't forget you've got the chat facility, so if you wish to ask a question off camera, you can always make a comment, or you can ask a question by using that chat facility at the bottom of your screen. Okay, let's talk about Australian legal history. And in particular, the material that you'll find in the new lawyer. I want to talk about Indigenous Australians and the law. And I'll make some comments, and I really do invite you to interrupt me as we proceed. So I don't want this to really become a lecture per se, but I'll provide some guidance and you can add some commentary if you wish. Okay, so if anyone wants to join Josh, who's going to communicate through chat, I encourage you to do so. As an exam hint, can I just say that I'm very keen on having you understand the history to Australian law, both in terms of the Indigenous law and also in terms of the English background to it. And if I look distracted from time to time, it's because I'm working this Zoom session and muting microphones that might be not muted, things of that nature. All right, so Indigenous law, we're talking Aboriginal and Torres Strait Islanders. In Queensland, we have the Murray community. Until recently, for a period of time, we had Murray courts, which were specialised courts dealing with Aboriginal matters. Close to where I live in Hervey Bay, there was one in Maryborough. That was, in my humble opinion, a very good innovation, but it has been scrapped of late, so we don't have that anymore. Aboriginal law is quite complex. It's very different to English law, if I can use that term, where predominantly our law has derived from. And you'll see that there's commentary from Catherine Trees. This is referred to at page 87. And customary law deals with elements of spirituality, ceremony, and business, as well as the law itself. Unlike our law, which is intended to be published and considered perhaps in an open forum, a lot of customary law was kept secret and was known and preserved by small groups. You will need to understand the decision in Maro. I trust that many of you have had a look at that. So that's Maro against Queensland, that's number 2, 1992, 175 CLR 1. Just as an aside, you'll notice that I didn't say Maro versus Queensland. We don't say that. And you'll give yourself away as a non-lawyer if you use the word versus. So typically, most lawyers will refer to a case by referring to the word and, where it says the small v. So in this case, I'm talking about Maro and Queensland. You should have a look at the actual case. You can do that by 2 sources. Can anyone tell me how do you access a case? Apart from reading a summary in a textbook, how do you actually get to the case? Is anyone able to offer an opinion?
The best way I've found is to go into the Commonwealth law reports, particularly if it's been heard in the High Court, which Maro was.
Very good. Thanks, Erin. And how do you get to the Commonwealth law reports?
Google it.
We're getting closer to the answer that I'm after. Thank you.
Go through the law library.
Yes, closer, but more specific. What sites specifically can we go to in order to get to a case? Any case. Maro's a decision. What was that, Erin?
Westlaw?
Yes. Westlaw will provide you with links. Bill's given me one of the 2 answers I'm after. Ostley. Thank you, Bill. Ostley is not authorised. Comlaw. Very good. Thanks, Loree. So, yes, we go Google. You're entirely right, Erin. Google, go through Westlaw, but the primary sources are Ostley or Comlaw, and Queensland has its own counterpart. So if you haven't had a look at Ostley, for example, which is one of my favourites, please do that. AUSTLII. And you'll find a lot of interesting material. It's important that you start to find your way around that. All right, so you've found your way to Maro. You've got an idea of what that decision is all about. And when we look at the historical context, you would note that Maro was significant in that it introduced, through the concept of judicial activism, essentially a new law. And the new law was that the doctrine of terra nullius was now no longer going to be part of Australian law. The previous law, which was introduced through the English coming into colonise Australia through terra nullius, was that Australia is deemed to be unoccupied land, which was, of course, both practically and legally something of a nonsense. But it finally took the High Court to come to that decision formally in the Maro case. That decision could have been overturned by the Commonwealth Government by simply introducing legislation to effectively mean that the concept of terra nullius does exist. But the federal government decided to, in fact, embrace the decision and the concept which was found by the High Court in Maro, and they did so by introducing and passing the Native Title Act, which was in 1993. So that legislation established effectively that the concept of native title did exist, therefore terra nullius did not exist, and the Act also took up the opportunity to introduce the executive or administrative regime that goes with the concept. All right, WIC against the state of Queensland sparked some controversy when the court decided that a pastoral lease did not necessarily extinguish native title, and that the federal government's response to that was to amend the Native Title Act. So I'm going to get you to have a look at Maro, understand the Native Title Act, and understand the concept of terra nullius. Have a look at Bates. I'm sorry, not Bates. I'll come back to that. Have a look at the commentary in the New Lawyer and read the source articles. Okay, so just in brief terms, in terms of the English law, Australia inherited the existing common law and legislation of the United Kingdom. Now, if I'm starting to lose you here, just let me know. Look at me blankly, ask for something in the chat facility. But I am assuming that you've done your reading before we go to this course. So just briefly, common law is essentially the law made through the courts. One decision which is then considered by another court, and in many circumstances being the second court being bound by the decision of the first court. And legislation, of course, is legislation passed by Parliament. Anyway, Australia inherited the existing common law and legislation of the United Kingdom. That was possible because initially Australia was deemed to be terra nullius, meaning unoccupied land. So that's what the British did. They declared Australia to be empty land, and as a result, of course, there was no treaty with the Indigenous Australians. So Australia was settled rather than conquered in that early stage. The Indigenous legal system was effectively ignored by British settlers, and the English law, the British law, was applied in relation to the new colony. So in 1992, as we've discussed, the High Court overtook that principle and overturned the doctrine of terra nullius. Okay, so Maro.
Can I just ask?
Yes.
Can I just ask, what is the difference between being conquered and settled? If it was conquered, what would have been the consequences?
Probably a treaty, as was the case in, I think, New Zealand. Yes. So effectively, by declaring the land empty and settling the land, there was absolutely no recognition of the Indigenous law.
But John, overturning terra nullius, doesn't that then imply that land was conquered and not settled?
Well, the way I read terra nullius was the concept that the land was empty. There was nothing to conquer. It was just a matter of moving in, as opposed to conquering the land and overtaking the existing inhabitants.
Right.
I hope that clears that up, Michael.
Well, sort of, but they overturning terra nullius suggests that. Well, I thought it suggests that it wasn't empty. So, but yet they're still affirming that it was settled rather than conquered.
Yes, and I see your point. So, in the context of what happened in 1992, you know, on the one hand, by saying that terra nullius is no longer good law, or the concept is dead, does that therefore, by necessary implication, mean that it must have been conquered?
Yeah.
Well, I think, look, I see your point, and it's a really good point, and I hadn't actually considered that, and I'm not sure anyone's raised that in previous incarnations of this little chat that we're having. But it certainly wasn't, the High Court didn't go so far as to say that therefore the British conquered Australia. I think that type of thinking is probably too remote in terms of what happened in Maro, and too remote in terms of the Native Title Act. But it is an interesting point. Thank you. Now, Peter said that terra nullius was overturned, but they didn't overturn the doctrine of reception. Thank you, Peter. Any other comments? All right, so for the examination purposes, I would like you to understand the Maro decision. I've got a lot of notes here. I would like perhaps for some exchange of information through UCrew or Moodle if you prefer in relation to that, and we can have some discussions about it a bit later. So I'm just flicking through my notes, and I'll move on to talk about native title determinations. The National Native Title Tribunal was established under the Act, that is the Native Title Act of '93, and it's the body that regulates the registration of all new native title claims. So the reason I'm referring to that is to highlight another thing that I want you to be very clear about in terms of your initial legal studies, and that is this concept of separation of powers. We talked about it last week. So on the one hand, we have the legislature, which creates the laws through Parliament. That is, when I say creates the laws, I'm talking about legislation. We then have the executive, which deals with the administration of the laws. And in this instance, through the Native Title Act, there was created a branch of the executive which didn't exist before, and that is effectively this concept of determining the tests and dealing with applications in relation to native title claims, and regulating those claims and making the appropriate regulatory notations. And finally, we have the judiciary, which deals with dealing with case law, etc. All right, so I haven't explained that well. I'm sure we can do better than that, and we'll come back to that at some stage. All right, the other thing that I wanted to discuss with you tonight was common law and equity. When we talk about common law, we're really talking about two concepts, and it becomes a little tricky. In general terms, common law means judge-made law. So we have a decision of the High Court which is on a particular topic, then that decision becomes binding on other courts, which are, of course, necessarily lower in the hierarchy of courts. So the concept which was decided in the High Court therefore binds lower courts when confronted with the same legal argument or same legal principle. That's common law in its pure term sense, and that is where one court is bound by another, and we talk about that in the context of precedent. So a particular case creates a precedent which must therefore be followed by other courts. Now, it gets a little complicated in the sense that if a district court comes to a particular decision in relation to a legal question, then you must be aware, or you must be comfortable with the fact that that will not bind a Supreme Court. In other words, it doesn't mean that higher courts are bound by the decisions of lower courts. So there is that hierarchy which must be taken into account. So that's common law in general terms. But historically in England, and you would have read about this in your material, there was a difference between the common law and equity. And I'd like you to have a kind of an understanding of this, again, potentially for examination purposes. So the common law was quite strict. It was dealing with black letter law. It was where decisions were made based essentially on the literal interpretation of what was stated in legislation. There was a whole branch of justice available to citizens in England in early times, and that was through equity, where essentially a petition to the king or queen, as the case may be, would be determined based not on the strict interpretation of legal rules, but rather on what was regarded as fair and an appropriate outcome. And eventually there were so many of these decisions that they started to become binding in equity. It was not until the Judicature Act of 1873 where essentially there was a merging of those principles, and the procedural difficulties were resolved by ensuring that the High Court of Justice in England was able to administer both common law and equity. So even today, you will hear lawyers talk about a remedy at law or a remedy in equity, or at equity, in equity. And so even though there is a fusion, there is still a distinction between those. Not every court in Australia has equitable jurisdiction. So let me give you a concrete example of this. Let's say you're a purchaser of property. You've signed a contract. The contract is binding. It's been signed by the seller. It's for a particular piece of land which is perhaps unique. The seller, for no good legal reason at all, refuses to settle. Well, there are different remedies available to the buyer. At law, the buyer is entitled to claim damages. In other words, say, well, I signed a contract to purchase this particular land for $300,000. I have a valuer who says that it's worth $400,000. So therefore, by denying me this land for $300,000, I am effectively out of pocket for $100,000, and that's the appropriate amount of my damages. So that's a remedy at law. We talk about at law or common law. Another remedy is to forfeit the deposit, to say, well, I'm sorry, I'll reverse that. So that's the claim that the buyer might have. Alternatively, equity would provide entirely different remedy, and that is a remedy called specific performance. And in specific performance, the buyer is entitled to seek an order of the court, effectively compelling the seller to proceed with that transaction and complete the transaction as if, the way they should have in the first instance. Now, the reason for that is that in equity, we would say, look, this is a particularly unique parcel of land, and damages is not an adequate way to deal with the issue. It was a proper contract and it should be enforced, and we call that equitable remedy one of specific performance. So you can see that remedies at law are essentially quite strict and literal. Remedies in equity provide some degree of flexibility and are all about what is a fair and just outcome. So if you had that situation, you couldn't go to the magistrate's court and ask for an order for specific performance, because in the magistrate's court there is no equitable jurisdiction. You'd have to go to the district court or the Supreme Court, higher up the chain. So not every court has a concurrent ability to deal with equitable and legal principles. Okay, now I've been doing a lot of talking. I don't see any comments on the Chatline facility. I'm looking to see, are there blank faces, or have I kept you with me? Yes, people are smiling a little bit, so I haven't lost you completely. All right, are there any questions in relation to what I've said? I appreciate it. Yes.
Sorry. John, can you just repeat that bit about the Judicature Act in I think I missed the date, was it 1873, and what was the purpose of that again?
Oh, okay. All right. I'll just go back. So what we had was, this is England. We had the situation where there were equitable decisions being made effectively by the king or the monarch, but through the agency of a delegate called the Lord Chancellor. So the Lord Chancellor essentially had run of this court, which was based on equity and good conscience, and that was called the Court of Chancery. So they started to follow their own decisions in equity, and on the other side of the coin, we had the judges that were dealing with the law, the strict legal principles, and you had these two systems that were running side by side. And if there was a conflict between the two, then the rule of equity would prevail. But essentially, we had these two courts running side by side, and they didn't join up in any real form until as late as 1873, where the English Parliament resolved by the passage of the Judicature Act of 1873 that the High Court of Justice was able to administer both common law and equity. And that was essentially the first sign of a fusion or a coexistence in the one court of those different remedies that had previously been entirely separate. I hope that answers it. Yes. Thanks, Aaron. Are there any questions or comments? Okay. All right. I'm going to invite you to read about some equitable principles. They still exist. We call a lot of them maxims. So I'll just give you a few examples. Equity will not suffer an injustice, and equity acts in personam. Equity follows the common law. One who seeks equity must do equity. One who comes into equity must come with clean hands. So there's some others. Equity will not aid a volunteer. Where equities are equal, the law will prevail. Equity looks to the intent rather than the form. Okay, so let's have a look at that one. These are just different maxims. They're just little sayings which go to describe what equity is all about. Equity looks to the intent rather than the form. Okay, what does that mean? Well, common law, as I said, was very rigid. It was very inflexible, and it couldn't respond appropriately to circumstances that were arisen or that were presented before it. So in other words, the form of the transaction was regarded as more important than the substance. Very strict, very literal. So it looked at the very letter of the agreement, not the intention behind it, whereas equity looked behind to determine the spirit rather than the letter of the law. It looked to the intention of the parties and not necessarily as strictly at the words. I've talked about the sale of land, where equity allowed flexibility in terms of remedies that were available to it. And also, for example, there's a legal concept of time of the essence, which we see in real estate contracts. Equity is far more flexible than that, and it will allow people reasonable time in circumstances to complete a transaction, even though they might be late. So that's part of the difference between equity and common law. Another thing is relief against penalties and forfeiture. Common law looks at the literal form of the contract and provides compensation, even though the actual loss may not be much, whereas equity will look at the object of the contract and provide for the opportunity for it to be performed specifically. Gosh, I'm saying a lot of words like this. Would equity be more in contrast to morality? I guess you could argue that equity is more is more closely related to moral obligations, but not really. You can't make that direct comparison. All right, so have a look at equitable maxims. Try and get some feel for the difference between common law and equity, and have some idea of some equitable remedies that would be available, and try to understand how they might be different to legal remedies. Right, we'll just move on. And if there's any questions, please post them on the chat facility or just jump in. The Statute of Westminster 1931 provided the British Parliament would no longer legislate for the Commonwealth of Australia. And in 1986, very recently, the Australia Acts came into force, which effectively severed the legislative ties between Britain and Australia. So that was all quite late in the piece. All right. I'm just going to make a few comments about Chapter 4, the Australian legal system. I'll get you to read that for yourself. Have a look at the 7 characteristics of the Australian legal system: the rule of law, liberal democracy, common law legal system, constitutional monarchy, federation, separation of powers and responsible government. Those 7 characteristics are defined in Chapter 4 of your text. Each should be read and understood for their contribution towards the Australian legal system. And have a look at the Parliamentary Education Office website. I think someone mentioned that on UCRU, and it's great. It's a great resource. So definitely have a look at that, the Parliamentary Education Office website. That has some really good commentary in relation to it. Now, I know that you all want exam tips from time to time. I think you all would appreciate the way in which this course will be examined. You have the 3 assignments. The first one, which deals with a case, reviewing a case. The second one dealing with legislation. The third is your progressive blog, your reflection, if you like, on your studies, which all of that accounts for 40%. Now that leaves 60% for the exam. And the exam will be 6 questions, each worth 10 marks, to be answered out of 7 choices. So there's only 7 choices on the paper. So you get to choose 6 of those 7, and each one of your answers will be worth 10%, making up the 60% for the exam. It is an entirely open book exam. So what that means is that you can take in your textbooks, you can take in legislation, you can take in cases, you can take in your own notes. If, for example, after tonight, you've got an inkling that there might be a question about separation of powers, or there might be a question about the significance of Maro and the Native Title Act, or there might be a question about the distinction between common law and equity. If you think that one of those or more of them might be on the paper, then you can start to write your answer for the exam now, because you can take that answer in. So it's great having an open book exam because you get much more time to prepare for it, and in that way there's less pressure. But there is a downside, and the downside is, of course, that the expectation is that the response and the material will be of a much better and a higher standard than if it was a completely closed book, which is far more reliant upon memory. So just be aware of that trade-off. And I'd encourage you to start studying now, but do so on the basis that there will be this opportunity for you to effectively write your answers. Now, when you get into the exam, you're not allowed to take laptops, and you're not allowed to take anything that will access the internet, and it all is handwritten. So if you have specific issues with handwriting, you can't write, for example, then you'd need to take that up now. Not with me, but with vocation and learning, I believe. But effectively, you'll be handwriting your exam. Don't worry, I'm pretty good at deciphering handwriting. So those people that write quickly and not well, don't be concerned. Now, there is no multiple choice. Last year there was multiple choice, but there is no multiple choice this year. Now, you might say, oh, that makes it tougher. But bear in mind that when we ran this course with multiple choice, I taught much more widely. There was a lot more material. So it's been condensed, and so that's the advantage and the disadvantage. All right, are there any questions? There's nothing coming through on the chat facility. Yes, and Peter, you're right. I've mentioned separation of powers a few times, haven't I? So I would encourage you to understand that principle. Thank you, Peter. Where do distance students take their exams? Check with the university on that. I know that distance students in the past, for my subjects, have taken their exams all over the place, all over the world. There are different venues for examinations to take place. But you may have to travel, I'm sorry. Best if you make those arrangements now. Are there any other questions? Okay. All right. Well, once again, thank you for your enthusiasm. Please have a look at that sample document of mine. Read it, as well as look at the format of it. Start to think about how you're going to frame your questions for the examination. Start preparing for those now. I'd recommend that you start to get some skeletons. Not out of the closet, but I'm talking skeleton answers ready for the examination purposes. Okay. All right. Well, I'll stop recording and we'll see you next week. Thank you.